We so appreciate your all being here for the first Innovations in Health Law and Policy, Regulatory Challenges and Strategies for Change Symposium. We welcome you today. It's going to be a wonderful program. This is put on by the UNH Health Law and Policy Programs and sponsored by the Rudman Center. And before I go into much more detail about the program, I want to turn it over to our our interim dean, Jordan Budd of UNH School of Law.
It's really a pleasure to welcome you to UNH School of Law today and to the Rudman Center for Justice, Leadership, and Public Policy for the inaugural conference, one I think the first of many to come, of our new program in health law and policy here at the law school. The program's led by Professor Lucy Hodder, who joined us last year and has taken the place by storm in just the several months since then. She has partnered with our faculty to develop a rigorous and innovative curriculum in health law, both as it relates to health law policy and also the healthcare industry. Professor Hodder's program is a joint undertaking here at the law school with the College of Health and Human Services, and in particular, its Institute for Health Policy and Practice. And it promises, I think, to make UNH an even more powerful engine for healthcare-related research and policy leadership, as well as now going forward, a destination for the training of excellent lawyers for our state and for our region to service our growing healthcare industry and assist our health law policy leaders. So we're really excited about the launch of this program. The program, though, is not simply limited to its research and teaching mission. It is also, and importantly, going to be a destination, a place where important conversations about healthcare and health law policy take place. And today's conference, organized by Professor Hodder and reflecting her incredible energy and vision and enthusiasm, we believe will be the first, obviously the inaugural and the first of many efforts in that regard, bringing together the kinds of extraordinary folks we have in the room today, advocates, policy leaders, scholars, who will be joining us for conversations going forward about the important issues relating to our healthcare industry. We couldn't be more excited about the journey ahead and the central role that our university will be playing going forward in the state and in the region as we all negotiate the incredible challenges of healthcare in the 21st century. Thanks to all of you for joining us. It's really a pleasure to have you with us for what will be, I'm sure, a terrific day of conversation and ideas about obviously one of the most difficult and important areas of public policy that our nation faces. It's my great pleasure to introduce to you now my friend, my colleague, partner in crime in launching this great initiative, Dean Mike Ferrara from the College of Health and Human Services.
Thanks, George. Well, good morning. It's great to have everybody here today. It's truly a fabulous tribute to Lucy and everything that she's done to bring this conference together in really a fairly short period of time. I remember when Lucy came to us, I think it was late spring, early summer, and said, I have this dream, and I want to make this dream happen. And so I said to her, Jordan, I said to Lucy, okay, let's make it happen. What do we need to do to support you? And by joining our forces together between the College of Health and Human Services and the School of Law, we have today's conference. And as Jordan said, and I want to echo his comments, we expect today to be the first of many, many conferences where we bring the leaders of New Hampshire together around this topic. You know, as I was driving here this morning, I was thinking of a quote. I said, what would be a good quote to talk about this morning? And I'm a big Steve Jobs fan. And you may have heard this quote where he says, we just don't build computers, we build a lifestyle. And he said that in the late 90s, early 2000s. And if you think about the computer industry, there was Apple, there's IBM, there's Dell, there's Gateway, there's HP, there are all these different companies. Now we fast forward that 15 years now, and all those other companies are gone, and Apple is going fast forward. And so when I think about the Health Law and Policy program, and I think about the collaboration that we have with the law school and with the Institute of Health Policy, I say, we're not just building a program, we're building a movement. we're going to take what we're doing here and our collaboration between the Institute of Health Policy and Practice and the School of Law and forwarding on what we're doing in advancing the mission of health law, health care, and health policy. We have a leadership position here in the state of New Hampshire. The Institute of Health Policy and Practice, IHPP, under the leadership of Joe Hodder, have set the stage for us in terms of research and setting policy for us in the state of New Hampshire. And by joining the strengths of IHPP with Joe's leadership and Lucy's leadership at the law school and her role with IHPP, our goal is to set the movement around health law and policy. So on behalf of the College of Health and Human Services, it's great to have you all here today, and we look forward to a fabulous conference. Thank you.
More thank yous to come, but we have some very important people here who are going to offer you some insights into their lives and policy. I just want to thank all my colleagues at the law school, at the college, and my wonderful team at IHPP who makes this all happen and worthwhile. The health law policy and programs are driven by the belief that incorporating the discipline of legal thought and analysis into health policy and reform is critical if we are to create an ethical and strategic models of care going forward. At the law school, we hope to train our attorneys to support our health providers, business innovators, and policymakers in and around New Hampshire now and in the future through a rigorous legal education and dialogue, and I welcome many of the students who are here today and have been helping with this event. I now have the distinct pleasure to introduce a very special person. She is an excellent lawyer. She is a fearless advocate. And she is a compelling leader in healthcare, and she has been since the beginning of her legal career. During her time as governor, she worked tirelessly with legislators, our federal delegation, regulators, providers, advocates, and families to ensure that as many citizens of New Hampshire as possible have access to affordable health care coverage. It's not always an easy job or easy work, as many of you in this room know. She's not been afraid of change. She has welcomed innovation. And above all, she's motivated all of us to help move New Hampshire down the road together to a healthier day. We're honored to have our governor, Maggie Hassan, here today.
Thank you very much, Lucy. Much of the effort that we made in the governor's office over the first 2 years of my term in particular around issues concerning health care were made possible because of Lucy's excellent skills, not only as a lawyer, but as a leader and as a visionary. And I am just very, very grateful. So Lucy, thank you so much for your work as well. It is great to be here at the UNH School of Law, and for the College of Health, thank you as well for your participation today. And Lucy is, in fact, the perfect person to be leading this new health law and policy program because I think as we have worked over the last few years, nowhere has it been more clear the intersection of getting it right both from a policy perspective and a legal perspective and a citizen perspective. And that's really what this combination of leaders in this room today will be thinking about, I hope, and addressing. Solicitor General, it is really great to see you as well. Thank you for joining us. I know in the audience, too, we have Cindy Mann, who, as director of CMS, really had a historical role in helping us develop our bipartisan health protection program. So Cindy, thank you. You are right over there. So thank you very much for your leadership and for the staff that you led, because without your partnership, we couldn't have done it either. So thank you very much. Rachel Caprielian, the regional director and our partner at DHHS, is also here. To Commissioner Toompas and all of the folks who are here from New Hampshire Health and Human Services, and Commissioner Savini, who is here from Department of Insurance in New Hampshire, thank you. I think I saw some elected officials wandering in too, and I thank all of them for their hard work For those of you who are here from somewhere else, know that our representatives and senators earn a whopping $100 a year, and they devote themselves to their work unbelievably well, and so I'm very, very grateful to all of them, as I am to everybody who is participating today. I think one of the most important changes we've seen over the past few years, especially in terms of public dialogue, has been our recognition as a state and as a country that the health of our people is critical to the well-being of our state and our economy. A healthy workforce is a productive workforce, and it really drives a thriving economy. Nowhere has that been more clear to me as when I have visited with healthcare providers over the last several months to ask them whether they have seen an impact since the passage and then coverage under the New Hampshire Health Protection Plan began. And they can tell you story after story of people who went from having urgent medical needs treated in the emergency room to having chronic medical needs treated over time with their primary care physician, and lives change. Everything starts with health, right? And so today's symposium is an incredibly important discussion, and one that I hope is just the beginning as we continue to take on this most fundamental public policy discussion and task. For those of you who either practice in the field of health law or who are considering it, just know how important health law as a discipline is to crafting good health policy. I was very, very lucky to enter this time in the governor's office with this issue in front of us with some background in health law, although Lucy spent a lot of time reminding me I was on inactive status, and that I really shouldn't opine on certain things. But nowhere has the necessity of understanding law, but also understanding policy and health as a combined set of issues been more clear than in developing health policy in this day and age. UNH Health Law and Policy Program is going to strengthen our efforts in New Hampshire and across the country. Today's symposium is a truly great example of the way in New Hampshire we bring leaders together, we engage in collective problem solving, and we can advance the dialogue that strengthens our healthcare system as a result. What we've done over the last few years in the state, among other things, with the help of many of you in this room, is brought more competition to our marketplace. We've improved affordability and increased choices for all Granite Staters. We've also, through the New Hampshire Health Protection Program, truly strengthened the health of all of our people, boosting our economy. Our successes include more than 42,000 Granite Staters now enrolled in the New Hampshire Health Protection Program. Thousands of those have accessed substance abuse and mental health services because, as you all know, the New Hampshire Health Protection Program, Medicaid expansion generally, now includes treatment for substance abuse and behavioral health. So critical not only as we rebuild our mental health system, which had really fallen behind and become incredibly strained, but in the middle of an opioid epidemic, incredibly important as we find ways to treat people faced with addiction and then help them into recovery. Our New Hampshire Health Protection Plan has also reduced cost shifting onto our families and businesses. We've seen, now documented well by the New Hampshire Hospital Association, a decrease in uncompensated care and visits from the uninsured to the emergency room. One of the examples that was shared with me by a healthcare provider in Nashua was the fact that she had a patient who she used to see regularly in the emergency room where the ER doctors did. She was diabetic, and that was the disease and symptoms that would bring her to the emergency room. And they would stabilize her with either very low or very high sugars, and she would leave again, but she didn't have the financial resources to afford regular insulin. So she would have, episodes and be in the emergency room, be discharged, and then be back. When the New Hampshire Health Protection Program started, and she became covered. She got a primary care doctor. And that primary care doctor discovered that in addition to diabetes, she had an untreated hernia, she had untreated infection. This is a woman who smoked and didn't exercise and didn't have a job. Now, a year after coverage, they treated the hernia, they treated the infection, her diabetes is steady. She, over time, gave up smoking and now exercises some. And for the first time in a long time, she holds a job. That's success. And that's what we mean about the foundational nature of good health policy in a democracy. I talked a moment ago about the importance of the New Hampshire Health Protection Program and the importance of good health care and public policy in terms of the substance abuse epidemic. It is our most pressing public health and safety problem and challenge in New Hampshire. It is affecting every part of our state, and it affects people from all walks of life. And I know everybody is very concerned about it, as they should be. I cannot go anywhere in New Hampshire without somebody talking to me about how it affects them personally. And I think you probably all saw a recent polling data, 50% of Granite Staters say they know somebody who is affected by the opioid epidemic. We have a multi-pronged, comprehensive approach focused on prevention, treatment, and recovery. I am incredibly grateful to our law enforcement officials who began shining the light on this even before our health officials did, and they did it in a classic New Hampshire way. They said, we will continue to work as hard as we can to stop the distribution of illegal drugs in our state, but they were really some of the first people to say, we cannot arrest our way out of this problem. And they were some of the first people to say to me, Governor, these people are sick, and we're not the best people to help them. A state trooper telling me he would do whatever he could to keep people safe, but he wasn't trained to treat people with mental health problems or addiction. And he understood that the two often occurred. So with that in mind, as we move forward as a state, we need to find ways to support resources to treat people with addiction. And the best, easiest way for us to do that is to reauthorize the New Hampshire Health Protection Program, a program that so many of you in this room were instrumental in developing. So please know that we are working every day to try to make sure those legislators who feel they don't know enough about the program to get information about it. Everything you can do to help them do that is critical, because right now we have a bunch of treatment providers in New Hampshire ready to expand capacity, but they can't make the capital investment if they think that the program will expire as it's currently set to do in January of 17. They need to know that those federal dollars that we all worked so hard to get, and that are federal taxpayer dollars paid by the people of New Hampshire, we need to get those back into the state past January 17. We need to let our providers know that we are committed to doing that. So as soon as we can reauthorize the Health Protection Program, we'll have another tool in our arsenal to increase treatment capacity and bring in those tens of millions of federal dollars to the people of New Hampshire and the families of New Hampshire, and attract providers help here. And while we are treating the disease, we will also keep on working on prevention, keep on working on a network of recovery services, and keep on making sure that our law enforcement have the resources they need to prevent the drugs from coming to our state and reaching the streets to begin with. I want to thank you all again, not only for the particular work you're doing in the arena of health law, but also on the importance of what you're doing in recognizing how important thoughtful, participatory public policy making is in a democracy. I'm looking, the lineup over here is Jeff Myers from HHS and then Roger Savini from insurance. For years, the insurance department and the Health and Human Services Department in New Hampshire didn't have that much to do with each other. You guys regulated insurance departments, you guys regulated health, and in some cases provided health insurance. Today, these two departments need to work as closely together as ever, because we are increasingly understanding the importance of public-private partnerships, of the role of both private sector and public sector in ensuring that each and every Granite Stater knows, and each and every American knows, that they count and they matter, and that starts with their health. It starts with their well-being as individuals and as families. When people are healthy, when they know if, God forbid, they are faced with an illness or an injury, they can get care, and then it won't bankrupt them, and that it can be the kind of care that can help them continue to function and participate in our democracy and our economy, then we all get stronger. More than anything, we are seeing rapid changes in healthcare and rapid changes in the economy, and we need to be able to support all of our people as they learn how to participate in a 21st century economy. And we need to do that not only for their sake, but for our businesses' sake as they face a growing workforce shortage. It is a governor's job to insist sometimes and persist, but it is the fact that all of you listen to that call and put your best talents forward to help us actually find solutions that achieve the vision. That's what makes us work as a democracy. And that's why I am so grateful for each and every one of you being here today, for the work you do, for the role you play. We have a lot of work ahead of us, but think of what we've achieved over the last few years as we've dealt with rapid change and some real challenges, but we've done it well, and we are stronger as a result. Thank you so much for having me. Have fun today. Long life.
It gives me great pleasure to welcome to UNH School of Law the 46th Solicitor General of the United States, Donald Verrilli. General Verrilli has had a remarkable career in constitutional litigation and public service. He's represented our nation before our highest court since 2011, when he succeeded his predecessor, Elena Kagan, upon her elevation to the United States Supreme Court. Prior to his appointment as Solicitor General, General Verrilli served as counsel to President Obama. He was Associate Deputy Attorney General in the U.S. Department of Justice. And prior to that, he led the Supreme Court practice group at one of the nation's leading Supreme Court advocacy law firms, Jenner & Block, where he established himself as one of the nation's leading advocates before the High Court, and also one of the leading examples in American law of doing good while doing well. He was a leader and has throughout his career been a leader in public service and pro bono as a member of the private bar, as well as now a leader of one of our most important public offices in American law. His arguments before the Supreme Court have spanned the broadest spectrum of issues in American law, ranging from an argument recently he was actually mentioning to me last night about the patentability of an extracted human gene, all the way to the most fundamental questions about the definition of human dignity and autonomy under the Constitution of the United States. He represented our government last term before the Supreme Court in the litigation over marriage equality, played a central role in the process that has led to the end of marriage discrimination based on sexual orientation in our society. And most relevant, I suppose, to our gathering here today, he also represented the United States government in both of the legal challenges brought to the Affordable Care Act since the statute's passage, prevailing in both cases and securing that legislation for our nation going forward. He's among an elite group, an extraordinarily elite group of attorneys who have argued, living attorneys, I would think there's probably no more than 10, who've argued in the United States Supreme Court more than 40 times. And for any lawyer, that's just a mind-boggling achievement. 40 appearances, more than 40 appearances before the United States Supreme Court. It's a measure of the extraordinary impact and reach of his work as one of our nation's leading legal strategists and advocates. It's truly hard to overstate or even fully grasp his impact on the American legal landscape. But he's touched many cases, but most important is the way he has touched those issues. His tenure as Solicitor General of the United States and his career prior to that has been marked by really the finest standards of work in the legal profession. Brilliant analysis, clear and incisive advocacy, and a profound respect for the facts of each case and for the dignity of the process of judicial review. As a personal matter, he's also one of the warmest and most kind and generous public officials I've ever had the pleasure of meeting, as evidenced just yesterday when he and his wife, Gail Laster, the equally formidable Gail Laster, joined me here at the law school on a Sunday afternoon for an hour-and-a-half conversation with a group of 12 of our students who are interested in public service. It's a private conversation sharing perspectives about their life as advocates in public service and in the private sector, and talking through with those students their own hopes and aspirations to make a difference with their legal careers. It was an extraordinary moment for those young people, and I can't thank the Solicitor General enough for making that possible. We are truly fortunate to have him as the nation's representative before the United States Supreme Court, and we are equally fortunate to have him with us today. It's my great pleasure to introduce the Solicitor General, Donald Verrilli.
Well, thank you, Jordan, for that really, really gracious introduction. I'm really happy my wife, Gail, was here to hear it. And thanks to you and to Mike, and especially to Lucy, for putting this fantastic conference together and for including us in it. We were fortunate to be invited up here a year and a half ago to participate in the UNH Law School commencement exercises. And Gail and I spent some time up here visiting with the law school community and with the legal community here in Concord. And that experience left us with a very firm impression that it's a really special legal community. It's a really special law school. And it's just great to be here and be back here and be a part of it. So thank you. What I'd like to do is this. I know that over the course of the day today, you're going to be focused on where we're headed and on matters of health law and health policy. And what I'll try to do is set the stage for that, and for that extremely valuable discussion, to take a little time and talk about where we've been and where we are now on the legal front, on the litigation front. And I'll spend some time doing that, but I want to try to reserve a significant chunk of time for questions, because I think, for me at least, that tends to be the most interesting part of this kind of a session. And so I will try to do that, and hopefully we can have a nice discussion with some questions. You know, it's hard to believe, at least for me, it's hard to believe that it's now been 5.5 years since the Affordable Care Act was enacted into law. And for me, it feels like about 5.5 minutes. There are many things we can say about that. One thing we can say for certain is that the Affordable Care Act is a litigation-generating machine. If you think about all of the litigation that has arisen out of that law and continues to arise out of that law, with new lawsuits being filed as recently as last week, it's quite something, and that's likely to continue for a while. But I do think we've reached a point where we can say that the really momentous issues under the Act have been settled. And so what I'm going to start talking about big picture, what's been settled, what remains unsettled, and then talk a little bit about some of the litigation that's on the immediate horizon. Of course, the main big picture point, as you may have heard, is that the Supreme Court has now upheld the lawfulness of the Affordable Care Act twice. And because most of you here today know the court's decisions in National Federation of Independent Business versus Sebelius and King versus Burwell, more or less backwards and forwards, I'm not going to go into the legal details in any significant measure. Although, as I said, I'm happy to answer any questions you might have about them when we get to that point in the discussion. I do think it's worthwhile to make a couple of observations about exactly what is settled and exactly what remains unsettled in the big picture. One thing that's now settled is that the basic operation of the Affordable Care Act and its regulation of private insurance markets is constitutionally legitimate and is available in all states. The objective of the act, of course, was to make affordable insurance available to everybody who was in the private insurance market by prohibiting insurance companies from denying coverage or charging inordinately expensive rates to persons with pre-existing conditions. For persons who obtain insurance through an employer, ERISA and other federal laws largely take care of the risk of that kind of discrimination. But for people who have to purchase insurance on their own rather than through an employer, the underwriting practices had resulted in what was essentially a dysfunctional market that put insurance out of reach for millions of people, tens of millions of people. The Act's guaranteed issue and community rating provisions that no one can be denied coverage or charged exorbitant rates based on existing medical conditions set a norm for the market. But those norms can't function on a standalone basis. In fact, they're highly counterproductive on a standalone basis. And we learned that from hard experience in a number of states, including, I believe, this one, New Hampshire, during the 1990s when a bunch of states did enact standalone reforms. And the result was pretty much universally in those states the famous insurance death spiral. Knowing that insurance would be available to them when they got sick, many healthy people simply delayed the purchase of insurance. People who continued to purchase insurance were those with significant medical expenses, so the pool of those who were insured became smaller and less healthy, which squeezed the insurance companies, caused them to raise rates, which led to more people opting out of the system, which squeezed the insurance companies even more, until the only people who stayed in the individual market were those who absolutely had to maintain their coverage to get vital medical care, or those small number of people who were insensitive to price. And many insurance companies, of course, wanted no part of this and would exit the insurance markets altogether. So to avoid a replay of that death spiral, the Affordable Care Act included the two features that were at the core of the litigation in NFIB and in King against Burwell, the so-called individual mandate and the availability of subsidies. These features of the regulatory design rely on the tax system. The mandate is a tax penalty on individuals who go without insurance. The point of it, of course, is to create a sufficient financial disincentive so people who don't perceive an immediate need for care won't opt out of the system. And so that has the effect of keeping the pool larger, and it also has the effect of avoiding some of the cost-sharing problems that the governor mentioned a few minutes ago, in that some number of these people who perceive themselves to be healthy and not in need of insurance actually get sick or get injured and incur health expenses that they then cannot afford, which results in the cost of that care being factored into the rates that everybody else pays. And so the idea of the mandate is to deal with those two problems, and that's how it works. Of course, you can't put people in the position of having to purchase something they can't afford, and that's why subsidies are critical. And the subsidies in the Act are tax credits that are available to people who make between 100% and 400% of the federal poverty line to defray the cost of purchasing insurance. So that's the logic of the system in a nutshell. As a policy matter, we want an affordable individual market that doesn't discriminate against people with pre-existing conditions. We can't have that unless enough people participate in the individual market, so we need an incentive to get them to do so. The incentive system can't work if people simply can't afford insurance, so we need a subsidy system to make the incentive system work, to make the insurance system work. The market reforms work only if all three parts of the regulatory structure operate together. What NFIB settled back in 2012 is that Congress has the constitutional authority to enact that regulatory structure. There was no real question about congressional authority to enact the guaranteed issue and community rating provisions using its power to regulate interstate commerce. Those provisions directly regulate the terms of commercial transactions in markets that are inherently interstate. The fight was about Congress's authority to enact the so-called mandate that was necessary to make those provisions work. and to prevent the death spirals in the individual market. And while, as you know, a majority of the court concluded that the mandate couldn't be enacted using Congress's commerce power, the provision was upheld as an exercise of Congress's taxing power because, well, it's a tax provision. It's in the Internal Revenue Code. It applies only to federal taxpayers. It imposes a tax penalty that you pay as part of your taxes on April 15th with the rest of your taxes, and so on and so on. And so it is now settled that Congress has the constitutional authority to enact that provision. Now, what King against Burwell settled just this past June is that the regulatory structure of the act that I just described can function as Congress designed to function in all 50 states. And the reason that was an issue was because of the wording of a particular provision of the Affordable Care Act that authorizes the tax credits, the subsidies for purchase of individual insurance. And under the act, each state has the option, as you all know, to set up its own marketplace called an exchange to facilitate the purchase of insurance and to facilitate the purchase in particular using the federal tax credits. If a state chooses not to set up its own exchange, then the law provides that the federal government steps in and sets up the exchange in the state's stead. And the confusion arose because the provision in the Affordable Care Act authorizing the tax credits provided that they could be used to purchase insurance on an exchange established by the state. And that phrasing gave rise to the argument that Congress had authorized subsidies only in states that set up exchanges for themselves, rather than opting to allow the federal government to do so in their stead. Now, accepting that reading of the act would have resulted in a reproduction of the conditions that caused the death spirals in states that had chosen not to set up their own exchanges, exactly the same conditions that existed in those states in the 1990s. The Act's guaranteed issue and community rating provisions would have remained in effect in states where the subsidies were unavailable if you read the Act that way. So insurance companies would have been required to make insurance available to all. But without the tax credits to subsidize the purchase of insurance, most people in those states would not be able to afford insurance and would opt out. Only the sick would remain in the system. And so you would have also produced the highly ironic consequence in those states of converting a feature of the Act that was designed to respect federalism and give states a choice about whether to use their state resources to implement the Act into something very much the opposite of what Congress intended. The state wanted to forego setting up an exchange and rely on the federal government to do so. The price could well have been the destruction of its insurance markets in the state. Now, ultimately, as you know, the court rejected that reading of the Act, and it concluded that the language of the tax credit provision, when read together with other provisions of the law, could and should be construed to authorize tax credits in every state. So it's now settled that the Act's regulatory structure will function in the way that Congress designed it to function in all 50 states. And when I say settled, I mean settled. One option, and I don't just mean that I mean that in a specific legal sense. One option before the court in King against Burwell was to conclude that the statutory text was ambiguous and could be read either way the way the government read it or the way the challengers read it. And in that situation, if you have an ambiguous statute and the statute is administered by a federal agency, there's a doctrine in federal law that says that courts should defer to a reasonable interpretation of the agency about which meaning to choose. And the court had available to it that option in the case. It could have said we're deferring to the agency's reading of this statute. But the consequence of ruling that way would have been that a future administration could have changed the reading of the statute because more than one interpretation would have been reasonable on that view. And that is not what the court did. It did not hold that it was going to uphold a reasonable reading by the federal implementing agencies. Instead, what the court held was that it was going to, and it was its responsibility in this situation to decide the meaning of the statutory provision itself permanently. And that's what it did. And so it's a definitive construction of the statute that isn't open to future administrations to change. And that's why I say it is really settled, period. Now, the big picture issue that's left in an unsettled state as a result of the two major decisions is, of course, Medicaid. And that's really important. And I think all of you probably here appreciate this even more than I do. But the Act's private insurance market reforms that I've been discussing that were at issue in NFIB and King against Burwell really were designed to only close about half of the coverage gap. When the Affordable Care Act was enacted, the thought was that of the population of uninsured who would be reached by the reforms in the Act, about half would benefit from the insurance market reforms and about half would benefit from the Medicaid expansion. And in the NFIB case, as you know, the court held that Congress could not use its spending power to tell states that they had to accept the Medicaid expansion if they wanted to continue to participate in pre-existing Medicaid programs. The court held that the loss of federal funds, all federal Medicaid funds, was too coercive a threat to give the states a meaningful choice about whether to participate in Medicaid expansion. And so what the court did was interpret the act in a manner that gave states the choice whether to opt into the expansion and to do so without risking the loss of traditional Medicaid funding if they chose not to opt in. Now at this point, I don't have the exact count, but about half the states roughly have opted in, half have not. So there's going to be this continuing issue over time that I know you're going to spend a lot of time on today. It's quite important about the ways in which states can formulate their policies to try to opt in the future. And there's going to be another issue. We've seen it arise already once, and I think it's probably going to continue to arise on the Medicaid side. Of course, part of what the Affordable Care Act did was provide for the phasing out of subsidies that were provided to hospitals and other providers that covered the uninsured, covered people who couldn't pay for their own insurance. And those subsidies were considerable, but the Act designed them to go away on the assumption that Medicaid would be available in all states in order to provide coverage to the poor. And if Medicaid is not available in all states, what's going to happen when those subsidies start to trail off? I think that we've had some litigation about that already, which is settled, but that's going to be, I think, a friction point going forward. So, those are the big picture cases. I want to spend a little time now talking about the other area where there's really been considerable litigation. There's going to continue to be considerable litigation, I think, in the immediate future, and that's over the contraceptive coverage mandate in the Act. Now, the Act provides that insurance policies, including those that employers provide to employees, should cover certain essential health benefits, and then it delegates to expert agencies the task of deciding what those benefits should be. And as part of the rules governing the availability of women's health benefits, those experts determined that coverage for many forms of contraception should be available as part of insurance coverage without any copay or cost-sharing obligation to the woman who obtain it. At the same time, federal regulators realized that this requirement was going to raise issues for certain religious organizations. And so the regulators attempted to design accommodations for those organizations. Churches were simply made exempt from the requirement, and religious nonprofit organizations, hospitals and universities mainly, were afforded an accommodation, and that accommodation has evolved over time since it was first announced a few years ago. Initially, the religious nonprofits could obtain the exemption from contraceptive coverage requirements if they notified their insurance company, or if they were self-insured, if they notified their third-party administrator that they wanted to opt out. And at that point, the insurance company or the third-party administrator would provide the coverage directly to the employees of the opting out employer, and it would do so without any cost or legal obligation on the part of the employer. The federal government would essentially work with the insurance company or the third-party administrator to ensure the provision of contraceptive coverage. Now, after litigation clarifying that religious nonprofits had religious objections even to providing the notice to their insurance company or their third-party administrator that they wanted to opt out, the government retooled the accommodation again and provided that religious nonprofits could notify the government of their interest in opting out, at which point the government would take the initiative and deal with the insurance companies and nonprofits to ensure the independent provision of the coverage. Now, that set of accommodations did not initially extend to for-profit corporations, and that led to the first round of litigation that culminated in the court's decision in 2014 in Hobby Lobby versus Burwell. That was a case where Hobby Lobby, though a fairly substantial corporation, it's a closely held corporation owned by a small number of family members who had very strongly held religious beliefs, and their view was that their religious beliefs, it was not compatible with their religious beliefs to offer insurance to their employees that covered contraception. In particular, they were concerned that they were of the view that certain forms of contraception, in particular IUDs, were abortifacients, and that providing that contradicted their religious belief that abortion was sinful. And so they invoked a statute called the Religious Freedom Restoration Act to seek an exemption from providing contraceptive coverage as part of their coverage for employees. So what the Religious Freedom Restoration Act provides is that a person can claim an exemption from federal law if the person shows that the federal law imposes a substantial burden on their religious practice. If it does impose a substantial burden on their religious practice, then the government, if they show that, then the government's got to show that imposing that burden advances a compelling governmental interest and does so in a narrowly tailored way. And Hobby Lobby, the corporation and its owners, made the argument I described, that providing insurance coverage that covered IUDs was a substantial burden on their exercise of religion. And then it was up to the government to show, to see whether it could show that there was a compelling interest and a narrowly tailored means of achieving it. And what the court held is that it assumed really in a way that suggested it agreed that the government did have a compelling interest in ensuring that all women had access to contraception and without cost sharing or co-pays through their employer health insurance policies, but that the government had not shown that its approach of requiring employers to provide the insurance was the most narrowly tailored means of achieving that end. And the reason the government didn't show that, the court said, is because the government had offered this accommodation to religious nonprofits that I described earlier. And what the court said is, well, look, if you provide this to religious nonprofits, why can't you just provide it to everybody? You haven't shown that you can't do that. And so for-profit corporations ought to be able to have the same ability to opt out. At least closely held for-profit corporations like Hobby Lobby was, where it's a small group of family members that own the company, ought to have the same ability to opt out. So we did lose that case, and then in the interim, the federal government's enacted regulations to try to put that kind of accommodation in place for for-profit companies. What's that's left us with is the question of the lawfulness of the accommodation that's been provided to religious nonprofits, the one I've described before. There's been litigation all around the country, and that has now kind of bubbled up to the Supreme Court, and there are a half a dozen or so petitions for certiorari pending. And so, and the religious nonprofits are saying even providing the government with notice of their desire to opt out is a substantial burden on their religious practice, and that's because the providing of the notice, in their view, triggers the process by which contraception will be provided as part of the insurance coverage to their employees, and they consider that sinful. I think it's highly likely the court's going to put the case on the docket. I think it's highly likely they're going to put the case on the docket soon. There's a split among the courts of appeals, so different courts of appeals have different views, and so that's, I think, will be the next major piece of litigation in front of the Supreme Court. There's significant other litigation going on in the lower courts. I think your next panel is going to talk about it. So rather than spend any more of our time together talking about that, I'll leave it to the next panel. And why don't I stop there, and I'd be happy to take questions. Well, somebody must have a question. Yeah, Nick.
So one of the surprises in King against Burwell is that there is not much discussion of federalism on the face of the opinion. There's not a discussion of whether we want to avoid a constitutional problem, which is what Justice Kennedy posited in a oral argument, and there was not even a discussion of the Pennhurst doctrine, which was sort of brought up as a possible way for the court to resolve an ambiguity. And I was curious if you had any thoughts as to why.
So I don't know. You never know how they shape the decisions. We did argue, one of the important arguments we made in King against Burwell was essentially an argument that, look, if you read the statute the way our opponents are saying you read it, it's incredibly unfair to the states. It puts them in a terrible position. And so we try to invoke principles of federalism to say you shouldn't construe the statute that way because of unfairness to the states. And that was an argument that was discussed at oral argument a fair amount. It came up a fair amount during oral argument. It was not reflected, as Nick suggested, at all in the ultimate opinion of the court. And the best explanation I can offer, but it's totally guesswork, is that I think that it was a case that had a high level of public significance. It was being very closely watched, and therefore there was a premium on having a single opinion that articulated the result rather than a fragmentation of opinions in which different justices had different rationales. And so if I were to speculate on a reason why it didn't end up playing much of a role in the ultimate outcome, I think it was because they looked for common ground on which all the justices, all 6 of the justices in the majority could stand. So. Yeah.
Yeah, I'm Jennifer Patterson from the New Hampshire Insurance Department. I'm wondering if you have anything that you can add about the Gobet versus Liberty Mutual case, which is scheduled.
Yeah, so that is going to be, I was going to talk about that, but in the interest of time, I didn't. I know you're going to talk about it in the next panel. I'll just say this, you all know about this case. It's in front of the court. I think it's going to be argued next month or the month after. And so it's a case in which whether the question is whether the law of your next door neighbor, Vermont, is preempted by federal law. Vermont's got a law that requires insurance companies and healthcare providers to submit data to the state about the cost of providing medical services, essentially, and then the state takes that information and makes it accessible and available to the public, so the public can use it to make wise decisions about how healthcare purchases and healthcare policy can be set looking at that data. The question is whether the federal law reporting requirements in ERISA and the Affordable Care Act, which does impose some roughly analogous reporting requirements on insurance companies to report data to the federal government, preempts the state law and renders it inoperative. The United States has filed a brief, a friend of the court brief in that case. We're not a party, but we filed a friend of the court brief in that case saying that the state law should not be preempted, that the federal law, this is not a situation where the supremacy of federal law over state law requires invalidating the state law, because the laws serve fundamentally different purposes. The state law is designed to do what I described earlier, allow people to make better health care choices, allow policymakers to set better health care policy. The federal reporting requirements are essentially designed to allow the federal government to regulate people who provide insurance coverage as part of an employee plan as fiduciaries. It's making sure that the fiduciaries can abide by their fiduciary responsibilities, and that's just fundamentally different from what Vermont is trying to accomplish, and therefore there's no reason to preempt. The court will either agree with that or it won't, and we'll find out by June.
And New Hampshire filed an amicus brief because, standalone amicus brief, because in New Hampshire, we've actually had that database for a long time.
That's good to know.
Prior to Vermont.
That's good to know. Good.
And we have been using it in our regulation of insurance market. So it's a very important question for New Hampshire.
Yeah.
As Solicitor General, as someone who's argued 40 cases in front of the court, you imagine you've got to obviously become an expert in a lot of the issues that you present to the court. How do you prepare for health law?
Yeah, so.
Particularly the team Burwell.
Yeah, it's a pretty remarkable thing actually in the job, because I do jump around, from, I'm arguing, if you just sort of think about it, I'm arguing about the president's authority under the Recess Appointments Clause 1 month and the constitutionality of the Voting Rights Act the next month, and whether you can get a patent on an extracted gene the next month, and it's like, it's quite something. And the main way I'm able to do it is really 2 things, and they're practical things. One is that, in our office, we do 2 moot courts before every argument, and they're incredibly rigorous. The young lawyers in my office just know how each justice thinks, and we get a lot of help from other lawyers in the federal government. So I do these 2 moot courts in like an hour in roll of question and answer, and then an hour of discussion afterwards. And those predict accurately about 90% of the questions I get asked at oral argument. And so if you know 90% of what you're going to be asked, you're kind of ahead of the game. And then the second way is I have the ability to draw on the expertise of the federal government. I mean, there are people in this room who actually help me prepare for oral argument in NFIB. And the example I'll use there, again, is this gene case, this question, the case is if a gene is extracted from the human body and isolated, can you get a patent on it? You can state the entire relevant law in like 2 sentences. If it's an invention, you get a patent. If it's a product of nature, you can't get a patent. And the problem is that you don't have any more law than that to answer the question, and the question isn't answered by law, it's actually answered by biochemistry and genetics. And I didn't know any biochemistry or genetics. What I knew was the phone number of Francis Collins, who's the head of NIH. And so I called up Francis, and I said, of course, Francis, as all of you do, I'm sure, right before he was head of NIH, he was head of the Human Genome Project, so he definitely knew what I needed to know. And so I called up Francis, and I said, will you help me get ready? And so Francis Collins came to my moot courts, and not only that, he sent me a team of 3 genius scientists from NIH. They came down to my office with a whiteboard, and they spent 3 or 4 hours with me, and they gave me a tutorial. And by the end of it, I knew what I needed to know. I knew the biochemistry I needed to know. I knew the genetics I needed to know to be able to explain our position. And so, that's a real benefit. Now, of course, that's totally flushed out of my brain. I can't remember any of it. Because that's just what you have to do when you're switching subjects so much. There's only so much space in there, and you got to get rid of the old stuff to make room for the new stuff. But that's how, basically, that's how. I think we have time for a couple more questions. Yeah.
Mr. Verrilli, I would love to hear how you would handicap the upcoming contraception and religious practice.
Yeah, and I'd love to be able to say it, but I absolutely will not. I'm sorry. I think they're likely to take it. I'll handicap it that far, but what they're likely to do, I don't think it'd be appropriate for me to say that because we'll be litigating it. So I'm sorry. I wish I could answer, but I just don't think I can. Well, I can take one more question. We have one? Yeah. Yeah.
So as I'm sure you know, Governor Scott from Florida filed a lawsuit following the Medicaid portion of the NFIB decision, claiming that at least what he thought was intended HHS action to condition a discretionary waiver of funding on whether or not the state expanded Medicaid violated the court's decision in NFIB. Where do you think the boundaries of the court's Medicaid decision is?
Yeah, there's 2 ways of looking. It's a really important question. I did sort of avert to, I think that's going to be a real friction point. So the point here is that Congress exercises its spending power. It says to the states, we're going to give you this money, but that comes with strings attached. And the question has always been, well, what are the constitutional limits on Congress's ability to attach the strings to accepting the money? And the doctrine had been that if the strings amounted to coercion of the states, then that crossed the line. That exceeded the authority that Congress had under its spending power under Article 1 of the Constitution. Prior to NFIB's Medicaid ruling, the court had never held that any action by the federal government using the spending power was coercive. It was the first time the court had ever held it in NFIB. And then so the question is, how much of an ongoing effect is that going to have? And I think it depends on which way you look at it. One way of looking at it is that the Medicaid expansion situation was unique in the following way. First, the expansion itself was a vast addition to the existing program. It was vast in scope. And second, the existing program, existing Medicaid, was itself vast in scope, such that the states were in a position of having to accept a vast expansion or risk losing something that was federal funding that was a considerable part of most state budgets and that would have undeniably led to significant disruption in the states. And that it's the conjunction of those 2 unique circumstances that created the coercion, and then that level of pressure in terms of the scope of the expansion and the scope of which it stood to lose is just unique. There's just nothing other than Medicaid that really comes close to that. The other way of looking at it, though, is that this is a principle that was launched out into the world, and like many legal principles, it'll start expanding. And and I think that it really just depends on how this litigation goes forward. The Florida case that you mentioned, the Governor Scott's case, that's settled pretty quickly, and I think, again, without opining on the merits of something that the courts haven't decided, I think you can read something into the fact that it's settled pretty quickly in terms of its strength, the strength of the argument. But I do think that's something where we're just going to have to stay tuned. I'm sure it's going to be a source of a lot of litigation over the years for the federal government. Okay, well, I think we're done. Thank you very much.